Okay. So we can, if we have any other questions, we can answer that now. Otherwise, we'll just give it about like 2 minutes and then I'll start opening
Mm.
up and then we'll just wait until people trickle in a bit. And then Keith, I can say to you, okay, Keith, we can get started now.
Yeah.
And then we'll do that. Perfect. What and George and Amber, you guys, you work from home? Are you?
I'm home. Usually Amber's in the office.
Yep.
Mhm.
Cool. And where is home for you, George?
I'm in St. James, near Smithtown.
Oh
Out.
yeah.
Yeah.
Okay. Right by me. I'm in Woodbury.
Oh, okay. Yeah, it's just a little bit further out.
Yeah.
Mhm.
Actually, one of our board members lives by you.
Oh, yeah.
Kate Cirillo.
Is
Yeah,
she in?
she's in St. James. She's in St. James.
Yeah,
Actually, Keith, yeah,
Keith
she
and I
should
met.
be calling us soon. What?
No, Keith and I met through the Long Island Capital Alliance. So I'm on the board, and Keith was a former board member.
Mhm.
Oh, what's it called? Long Island Capital what?
Oh,
Alliance.
Alliance.
Oh, do they still have that?
Yes, so we're
Yeah.
actually having an event December 9th that I'm organizing. It's more for food and beverage startups in Bayshore.
Well,
Yeah,
I could, yeah,
we
I'd like
do.
to attend that. If you want to maybe, send me that, that would be a great idea. I
Sure.
can go there and kind of, yeah, because I'm right here. Where is it going to be in Bayshore, you said?
Yeah, Bayshore, the I think the breweries,
Oh,
South Shore
okay.
Brewery, something like that. But yeah,
Oh,
I'll
did you
send
say December 9th?
December 9th in
The
the
the, the Blue Point Brewery.
blue. I believe so. Yeah,
Yeah,
it's
I
in.
do a running race that ends there, and like it's a 10 mile race, and we start at 9, and you're drinking beer at 10:40.
Yeah, it's a food and beverage companies, so we thought that'll be a good venue.
Yeah, that's a
That is
great venue.
cool. And you know
Mhm.
what? I actually am not able to make it December 9th because I'm actually out of the country then, but on after that, the next one, if
Yeah,
you
they have
are
them
interested.
quarterly, pretty
Yeah,
much.
yeah.
Yeah, I'll send you the information anyway, so you can look at the website and sign up for the newsletter.
Oh, cool. Okay, that'd be great. All right, I think I should start opening up. So don't
Well,
see anything.
give it one more minute,
Give it
Jamie,
a minute. Okay.
and we'll start at like third. I'll start at 11:31. Do the You'll read my part.
Okay, cool. And then George, yeah, Keith and I are gonna go off our videos and then
Mhm.
Well, I'll be on video, and then after I do the intro, then I go off.
right.
Yeah.
Okay. Yeah, Amber and I will
Meaning
stay
meaning you
on.
can't see us. We'll just stop our video. Yeah.
Yeah, if you see any questions pop up, feel free to stop us. Mhm.
Well, yeah, I won't even stop you in the middle. We'll answer that. We'll save any questions towards the end. So best case scenario would be if they popped up. So we have them for the end. That'd be great. All right, let me start opening up. It's 11:29. Okay. Hold on. Okay. We have our participants logging on now.
Hi, we're going to start in about 30 seconds. Good afternoon. Good morning. Well, happy Monday. My name is Keith Dreyer, and I am honored to serve as the Shills Fund president. Thank you for making time for us today. The Shills Fund is named for the late Dr. Edward B. Shills. We are a nonprofit organization dedicated to advancing innovative approaches and entrepreneurship in oral health. Dr. Shills was executive director of the Dental Manufacturers of America and a professor at the Wharton Business School at the University of Pennsylvania. He actually holds the record for the most earned degrees from the University of Pennsylvania. Ed Shills had an amazing entrepreneurial spirit and saw a need to encourage innovation and entrepreneurship. The Shills Fund is celebrating our 22nd anniversary and is cultivating a diverse generation of oral health leaders. Our Shills Fund Partnership Awards is for entrepreneurs who display innovative oral healthcare ideas that advance oral health and total health. Through a series of webinars and in-person nationwide practice pitch events, we are providing an environment to help entrepreneurs elevate their innovative ideas into a successful pitch with the goal of being selected for a Shills Partnership Award. Please go to shillsfund.org to apply for a future award. Our webinars educate entrepreneurs with best practices from leaders in oral healthcare, law, marketing, communications. These webinars cover topics in oral health innovation and entrepreneurship and the needs for the oral health industry. Welcome to our Powerful Strategies to Protect Your Intellectual Property webinar. We're fortunate to have two amazing speakers today. George Licorizos brings 20 years experience in procuring intellectual property protection for a diverse clientele, including inventors, small businesses, universities, and Fortune 500 companies. A partner at Carter, DeLuca and Farrell LLP, he is skilled in all facets of patent, trademark, and copyright law. George's expertise includes analyzing patents and IP portfolios in the context of litigation, mergers, acquisitions, product clearance investigations, and patentability studies, as well as preparing legal opinions and advising R&D teams. His clients span a wide array of digital health and medical devices, wearables, communication systems, software, and more. In trademark law, George oversees every stage of prosecution, from preparing trademark opinions to managing non-disclosure and licensing agreements. He earned a bachelor's in electrical engineering and a master's in operation management from NYU Tandon School of Engineering, followed by his law degree from Touro University Law Center. George's extensive experience makes him a highly trusted advisor in protecting and advancing client innovations. Also with us is Amber Roybu. Amber is a registered patent agent and is admitted to practice before the United States Patent and Trademark Office. She is experienced in patent preparation and prosecution, including drafting provisional and utility applications and preparing responses to office actions. Additionally, she conducts patentability investigations and assists in freedom to operate and landscape studies. Amber is skilled in a number of technologies, including medical devices, mechanical and electromechanical applications, chemical and biochemical applications. She earned her bachelor's in chemical engineering and has a chemical engineering experience. Amber earned her law degree from Touro University Law Center with a concentration in intellectual property law. So you've heard the official background from them. It's quite impressive, but now let's get to it and let's welcome our awesome speaker. George, take it away.
Great. Thank you, Keith. Thanks everyone for having us here today. I'll start off the presentation, and my colleague Amber will present later. Okay, some of the topics we'll cover today are what is intellectual property? Why does IP matter, especially for startups? Copyrights and trade secrets, protecting your trademarks and brand names, the importance of conducting trademark and patent searches, what can be patented, patenting software, what sometimes be referred as computer implemented inventions, international strategic patent portfolio development, US provisional patent applications and advantages, and then we'll conclude with IP strategies and considerations for technology startups. So what is intellectual property? Intellectual property is a general term often used for categories of rights and intangible creations of the mind. What we call the four pillars of intellectual property, they are copyrights, trade secrets, trademarks, and patents. Why does IP matter? So IP is a business asset, and usually the IP of a startup is typically its most valuable asset, especially for technology startups. It establishes protectable legal interest in the goods and services sold by a company and the technology and know-how used to produce them. It has intrinsic value that can be sold, licensed, or leveraged for profit. In case of trademarks, it builds brand awareness and loyalty among consumers. It gives a company a competitive advantage. You can sue for infringement or theft, and you can also partner with larger companies because you have an intellectual property portfolio. It drives innovation, it creates jobs, and enables a startup to get investment, enter new markets, and grow your market share. And it has been shown that technology startups with IP are significantly more valuable than other startups and often more successful. First, we'll talk about copyrights. Copyrights protect original works of authorship that are fixed in a tangible medium of expression, like a CD, a book. And also you can have copyrights on software. The original source code and object code are protected by copyright, just if a program was a work of literature. There's no such thing as an international copyright. And in the case of medical startups, so you know, medical images produced by X-rays, ultrasounds, magnetic resonance, or other imaging equipment are not copyrightable, but are owned by the facility that produced them. And there's a general right. The privacy rule requires HIPAA-covered entities, whether it's healthcare providers, to provide individuals upon request access to their health information. So health information, your medical images will be provided to you, even though they may not be owned by you. And copyrights are protected in different countries based on laws. In the US, EU, and Japan, it's the author's life plus 70 years. In Canada, it's the author's life plus 50 years. And if it's a work for hire, let's say you hire a software developer to make your software, it's 95 years from the date of first publication or 120 years from the date that it was created. Trade secrets, or otherwise known as know-how. So trade secrets are confidential business information that provides a competitive advantage. Some examples could be software, processes, formulas, marketing strategies, your customer list, and their personal data. And in the case of, let's say, you're making dental implants, the materials, the resins that you are using to produce those devices. It provides an economic value. It's not generally known by the public, or it requires effort and time to compile them. It lasts as long as you keep it a secret. Unlike copyrights, patents, and trademarks, there's no formal requirement with the government. As long as you keep it a secret and you take reasonable efforts to maintain the secrecy, the law will protect the trade secrets on your behalf. And when I say reasonable efforts, something like employee handbook, non-disclosure agreements, need-to-know basis, anything you can do as a startup that makes the trade secret less accessible by the public and almost nearly non-accessible. Therefore, somebody will not be able to publicly be able to get that information. These are reasonable efforts the courts will look at to make sure that you did all these things and be able to help you in the case of somebody misappropriating your trade secrets. But just be aware that trade secrets, since they're not formally protected by any government formality, they can be reverse engineered or independently discovered. And we'll provide these slides to you all. So you'll see throughout our presentation, we have links to various articles about different topics we'll be covering today, so you can get more information. So in the US, you can bring a federal lawsuit and recover attorney's fees. Like one example in the dental area was Serona Dental Systems versus one of their former employees. And in this case, it underscores the significance of having non-disclosure agreements to safeguard your trade secrets. So in this case, the court ruled in favor of the technology company over a former employee who unlawfully used the company's trade secrets to establish a competing dental equipment business. The fact that there was a non-disclosure agreement and the company did all the things they should have been doing to keep their trade secrets a secret, all these reasonable efforts and measures they took, the court sided with them. So it's important to protect your trade secrets because courts will definitely award you in the case they are misappropriated. Now we'll talk about trademarks. So what is a trademark? So in the second bullet point, a trademark is a recognizable sign, design, or expression which identifies product or services of a particular source from those of others. So in the first bullet point, the name of your dental practice defines your identity. So it's integral to protect this trademark because it's the first thing your patients encounter when they visit your office, and it's the primary identifier when people recommend your practice, your startup, or your goods. It lasts as long as you can show actual use. You can actually use the Madrid Protocol process to register your trademarks internationally and inexpensively. And always use the TM if your trademark is not registered. And when it does get registered, make sure you use the R with the circle for registered trademarks. And those are some of the dental practice, dental companies that have registered their trademarks as examples. So general trademark requirements. On the left, what can be trademarked? Letters, words, names, even last names. If they've been used as a source identifier, it can be registered. Images, shapes, color can also be registered, as well as sounds and smells. And there's also something called trade dress. If you have a certain product packaging that you're using or a design, if you use that for many years, the courts will identify that as your trade dress. Think about the Coca-Cola bottle or the Origina bottle. Those are shapes that have acquired trade dress protection. So if you're selling a product with that could be any different shape, perhaps think of using the same shape for several years to be able to acquire trade dress protection. And the trademarks need to have what we call distinctiveness in order to be registered and receive trademark protection. So on the right there, we have the 5 categories of distinctiveness. They are fanciful, for example, Invisalign. Basically, it's a made-up word. It could be arbitrary, where you have a known word, but used in a different setting, in this case, Apple computers. Suggestive, like routine dental, it suggests the services that you are offering. And then there's descriptive and generic marks, which are almost never protected. So fanciful, arbitrary, and suggestive are inherently distinctive and generally protectable if nobody else has registered the same name or similar sounding name. Descriptive marks need secondary meaning, or what we call consumer recognition, in order to receive protection. They have to be used for several years, sometimes many years, before the US Patent and Trademark Office can say you acquired secondary meaning in that word. And generic marks are never protectable. And usually generic marks were former registered trademarks that became generic based on the common ordinary usage in the English language, like escalator, trampoline, and flip phone. So you can protect your trademarks in the US and also internationally. There's 2 distinctions you should know. There's first use countries, and then there's first filer countries. United States, Australia, and Canada are first user of the trademark. So if you use the trademark in the US, Australia, and Canada, and you haven't registered, you can still establish priority rights over that trademark because you are the first user. In other jurisdictions like the EU, China, and Japan, you have to be the first filer of a trademark application to establish the right in that country or jurisdiction. So it's important. So if you're thinking of eventually expanding into the EU, China, and Japan, you have to file there first before anybody else does to get rights in those countries and in the EU. In the United States, Australia, and Canada, it's good to file as soon as possible, but if you can show prior use, you usually can establish earlier rights. And there are 2 options for international trademark registration. You can file directly in each country or jurisdiction, like the US Patent and Trademark Office or the European Union Intellectual Property Office. Or like I said earlier, you can go under the Madrid Protocol where you file in one country and then you use that filing as your priority filing to file in other countries using the Madrid Protocol. And that usually means that you can check the boxes, whichever countries you want to register your trademark. And if those countries agree, you get your registration. You don't need to hire a local law firm in those countries. Now, if you get rejected by any one country, then you have to hire a local law firm to argue against the rejection if you think you have a chance to overcoming the rejection. So the Madrid Protocol process involves filing a trademark application first in a member country like the US. Then you file your Madrid Protocol application, select the countries you want. Each receiving office will then determine, like I said earlier, you only need to hire local counsel if you get refused in any particular country. And just be aware that if at any time during that initial 5-year period, any receiving office cancels or rejects your trademark registration, all the international registrations based on that trademark registration will also be canceled or rejected as well. So you run that risk if you file in many countries and one country cancels your registration, it could have a domino effect in the other countries as well. So it's always good to do a trademark search, not only in the US when you're selecting the name, but also the countries where you think you may be doing business in, so you don't get any registration canceled or rejected at some point, and everything can go through and smoothly. So some factors to consider when filing internationally: where will your trademark protection provide you with future value? Where are your customers? Where are your services being provided? Where are your goods being shipped? Will you lose value, competitive edge sales if you're not registered in that particular country? And where are your competitors now in the future? Maybe those are markets for you as well. So think of those countries as potential future markets for your company. And now Amber will pick it up with patents.
Thank you, George. So we'd like to offer you a very high-level look at the world of patent law, which is really the more inventive and innovative pillar of intellectual property law. So patent law, just like the other branches of intellectual property law that George previously discussed, are founded in the Constitution. And so because of that, patent law is completely ingrained in federal law. And so in many ways, the founding father envisioned a nation where innovation was promoted and inventive thought was also promoted. And we didn't want to monopolize industries and different areas of technology. So from a very high level look, a patent is essentially your right to exclude others from, for example, making, using, importing, and selling your invention in the particular jurisdiction where you have been allotted patent rights. And so you, in some sense, in the United States, enter into an agreement with the United States Patent and Trademark Office when you're granted a patent, in which you agree to, first off, disclose your invention to the public. So you are no longer keeping it as a trade secret, which George previously discussed. You also agree to release your invention to the public after the patent term expires, which in the United States is 20 years from the earliest filing date. So that could be either the date when you actually literally file your application with the United States Patent and Trademark Office, or you could usually, in some cases, you can file priority to an earlier application if you are disclosing the same subject matter. So there are some statutory guidelines that need to be followed there, but generally speaking, it's 20 years from the earliest filing date. And there are a couple different types of patents that can be acquired. So the most common form of patents that we work with are utility patents, which are those that are functional in nature. So here you'll see methods, systems, apparatuses that are, seeking protection. There are also design patents, which are the second most common. These are more so aimed at ornamental design and protecting how something looks and, explaining why that particular look distinguishes from what's already out there. So it's really more aesthetic based than functional. And there are also plant patents, which are pretty rare. We don't see many, if any, at all. There are many firms out there that actually focus solely on plant patents. I believe one of the most prominent ones is down in Louisiana, but we don't really dabble in that area. It has its own statutory guidelines that need to be followed. But so yeah, just generally speaking, it's very important to keep in mind that a patent does not give you the right to make your invention, but it does give you this right to exclude others from making it. So it's really more of an exclusive right to your invention more than anything else. So from a general perspective, what can be patented. And this is really important to understand to proceed with actually protecting your invention. So in most countries, things like ideas, concepts, discoveries, scientific theories are not patentable. So pursuant to the United States Code and specifically Section 101, which really details what is patentable and what is not patentable, what would be considered patentable subject matter are, like I alluded to, processes, machines, manufacturers, compositions of matter that are new and useful. So this can take the form of a method of use, a system, an apparatus, things of that nature. There are also some statutorily defined exceptions. So those are things that are not patentable. So that would be laws of nature. So we actually just had the Supreme Court denied cert on a very prominent case about 2 years ago, where the application had been denied because the Supreme Court deemed that the invention was practically just demonstrating Hooke's law, which is just, a natural physical law of nature. And so it was not, patentable for that particular reason. Some other things that are not patentable are natural phenomena. And I think the most common 101 rejection that we see nowadays are on the basis of abstract ideas. And this is because of the prominence of artificial intelligence and AI being integrated into different softwares and programs that are being developed. So in order to get past this particular rejection, it's really important to clearly explain the steps of your AI or your software algorithm and show how it's specifically solving a real world problem and not, just set forth a theoretical solution. And that should help you get past that hurdle. So now looking into the other general US patent requirements, which again are all founded in federal law. First and foremost, your invention needs to be useful. So it needs to provide some benefit to society. That is, it has to have some real world use, and it really needs to have some potential application in a field or an industry. Additionally, which is protected under Section 102 of the statute, it needs to be novel, and this is really important. So it needs to not be disclosed by what we refer to as prior art, which is ultimately just the domain or landscape of existing protected patents or public applications that disclose this particular type of invention or field. So it cannot be something that's already publicly known. And, in many cases, it can be a very minuscule indicia of novelty that can get you past this particular rejection, but this is something that's very important to keep in mind. Then another requirement is that it has to be non-obvious, and this is protected by Section 103 of the code. And obviousness is a little bit more of a convoluted rejection that we see from the USPTO, and it gives examiners a little bit of freedom to combine different references to say, hey, if I take these two and combine them, it really just creates what you're saying. So obviousness looks at the difference between what's already out there and what is claimed in your particular invention. So you have to make sure that the prior art that's out there, even if it's not in one patent specifically, but the wide variety of it, when combined, does not suggest your invention. So, generally these patent requirements are the same in the European Union as it is in the US. But it is important to note that in Europe, surgical methods or methods of medical treatment are not patentable, but medical devices are considered patentable subject matter. So now, just to go through a very stepwise process of the prosecution process, first and foremost is the conception of the invention. So the invention must be conceived and the invention must be reduced to practice. But that does not mean that you have to have a working model or system, which is a very common misconception that we see. So it's really important to create a culture of IP awareness. So it would be smart to institute controls and procedures over the development of IP by employees and researchers. It's also best practice to document and report processes for IP. And invention disclosures should also be made mandatory for all researchers to be filled out. The second step is the patentability search, which is something that we always highly recommend as a firm. And this is a search that we would conduct to look at the prior art references that are already out there. And this is conducted prior to drafting the patent application to better understand what the landscape is like and where you might be able to potentially enter within that particular landscape. Nowadays, many industries are very crowded, so it's really best practice to understand what's already covered and what you can cover through your invention. The third step is also an optional step, but it is highly recommended, is filing a US provisional application. So we, in practice, consider this kind of a placeholder. So it holds your place in line at the USPTO, it gets you a filing date, but I will expand further on it in future slides. But it just requires an application, including a specification and a drawing. So oftentimes we will see inventors submitting slide decks or disclosures or research papers, and that's plenty for a provisional application just to get something on file with the USPTO. And these have a pendency that lasts about 12 months from the date it is filed. So you have 1 year in which you have to convert that application into the fourth step, which is a non-provisional application. So that's your final patent application. So in order for your non-provisional application to actually claim priority from the provisional application, that is, it would take the filing date of the provisional application. And the benefit with that is that you are safeguarded from anything that came out during that 1 year period of time. It must be filed within the 12-month pendency of the provisional application. So that's critical, and you really need to keep track of that. Now, the fifth step is actual prosecution. And unfortunately, it can be a pretty lengthy process, and it can be a little bit strenuous waiting for the USPTO to get back. And so this process can last anywhere from 2 to 5 years. And oftentimes the USPTO will send you something that we refer to as a first office action, which is where they will set forth arguments regarding the patentability of the application. So they might reject your invention based on some of the statutory sections that I discussed. They might say that your invention is not novel in light of what's already out there, or they might say that it's obvious in light of what's already out there. Or on the contrary, in a positive case, they might notify the applicant that the application is automatically allowable. The applicant then responds to the USPTO accordingly. So, we as a firm will file responses to these office actions, distinguishing the invention that has been filed against what's already out there. And it really is like a chess match. So that's what you can expect in the prosecution process. And then the sixth step is patent granting and the payment of issue and maintenance fees afterwards. So if the application is granted, the issue or grant fee must be paid within a predetermined time period. So in the United States, that's within 3 months from the date of the notice of allowance. And then to keep your patent enforceable, you do have to pay some maintenance and renewal fees intermittently. So in the US, you're going to be paying that at the 3.5-year mark, the 7.5-year mark, and the 11.5-year mark. And this keeps it alive. So, it's really important to note that keeping a patent application family alive is a really key patent strategy. So this is just an overview of everything that I just discussed. So those 6 steps that we went through, so you can see everything from the point of conception all the way up to the point of actually paying those maintenance fees. Now, like I mentioned, the prosecution process can be a bit of a strenuous process, and a lot of times there's a lot of waiting around that takes place. But there are some solutions for people that want to prioritize examination and expedite prosecution. So one of those methods is the Track 1 Prioritize Examination route. This is only offered in the United States. And this would provide you with final disposition of a US utility or plant patent application within 12 months, rather than that 2 to 5 or 2 to 6 year period that I previously alluded to from the date on which the Track 1 request is granted. So it can be requested upon filing of a utility or a plant patent, and that can include anything from a continuation application to a divisional application to a continuation in part application, which are just various forms of patent applications that can be filed. The one caveat with this is that there is an additional fee that needs to be paid, and that can range anywhere from $800 to about $4,000, depending on the type of application being filed. But many inventors do feel that this is worthwhile because they have that expedited prosecution. So it's a great option for people that don't want to wait around and see how long it takes the USPTO to respond. Now, as I previously discussed, there are many advantages that come with actually filing a provisional patent application, that placeholder application, even though it is not required. So it's important to note that a provisional patent application is not examined and it's not published. So the USPTO examiners are not examining the provisional patent application as they would a non-provisional patent application. Again, it's a non-extendable 12-month pendency. So if you do file a provisional application and you intend on claiming priority to its filing date, you do have to file your non-provisional, your final application within 12 months. The United States used to be a first to invent system, but it's since shifted to a first to file system. And so, that gives you the benefit of getting something on file with the USPTO before others have the chance to. And like I said, it establishes a priority date for prior art, and it postpones the decision to pursue domestic and foreign patent applications as well. And this gives you a 1-year period of time within which you can really flesh out your invention and better understand what you'd like to claim by the time that you actually file your non-provisional a year later. It's also very low cost compared to a non-provisional application. So there are, lessened attorney fees, lessened filing fees. So it's a really easy way to just get your application on file and get that date down. And you can get it to the USPTO very quickly because there are far fewer formal requirements than non-provisional applications. So you just need to get a specification on file and a figure, which is why many people will just file like a scholarly article or a disclosure or a slide deck, things of that nature. It really doesn't need to be quite as formal. Again, it affords you 1 year to prepare and file a non-provisional application and or a foreign application. And it also allows you the use of patent pending, which is very attractive to many inventors on potentially covered products. So you can immediately put patent pending on your product if you have filed a provisional application with the USPTO. But there are some limitations that do come with filing a provisional patent application. So something that's very important to keep in mind if you do choose to file a provisional patent application prior to filing a non-provisional is that any information that's not included in the provisional application will not be afforded the benefit of the provisional filing date when you later file a non-provisional application. So they really have to be mirror images of each other. You cannot bring in new matter and then claim benefit of that filing date on that new information. That will have its own filing date. So you have to be very careful to include any and all details of your invention that you think you will later pull in, which is why we say pictures are worth 1,000 words. So the more figures you can get in, the better. Those are things that even if you don't explicitly disclose, you have inherently disclosed. So you do have the option later on the non-provisional to expand on those particular elements shown in the figures without any issues. If possible, you should prepare the provisional application in a manner that complies with the same formal requirements as a non-provisional application for the best results, because of the reasons that I just explained, especially when you're anticipating foreign or European filings. And this is absolutely best practice. This is what we like to do as a firm as well, is to prepare them the same way we would prepare a non-provisional, so we don't encounter any issues later on when we try to claim benefit of the provisional filing date in the non-provisional. So now, one of the international options that is available to pursue to make it easier to file internationally is the Patent Cooperation Treaty Application Procedure. So that's shown briefly in this timeline, but I'll expand further on that. So the PCT program allows inventors to file a single international patent application. And this international patent application has the same legal effect as filing separate applications in each country that you're interested in. The application can be filed in one language at one patent office within 12 months of the earliest patent application filed for that particular invention. So there are also more than 150 members that partake in this particular program. So those are 150 countries that you can expand into. And it can be filed by anyone who is a national or a resident of a PCT contracting state. So just to briefly walk you through this timeline. So at the 0-month mark, this is when you file your local filing application. So this would be, for example, the filing of your non-provisional application with the USPTO. So this is where the process really begins. Then at the 12-month mark, this is where you submit a PCT application to seek international patent protection. And this step allows you to reserve rights in multiple countries later on down the line. At the 16th month mark, you receive the International Search Report, which ultimately assesses the patentability of your invention by analyzing prior arts, which again are the existing technologies or patents or publications that are already out there. Then at the 18-month mark, your application is published internationally, which makes it publicly accessible, and it marks kind of like the midpoint of the process. At the 22-month mark, you can request a preliminary examination to help refine your application and understand what you would need to fix to expedite prosecution in future countries, and to further evaluate patentability overall before you enter what we call the national stage, which is when you file your application directly in the respective country. At the 28th month mark is when the results of the preliminary examination can be expected. And this would provide a clearer understanding of the likelihood of you obtaining a patent in your desired countries. And then at the 30-month mark, this is the national phase section. So this is where you would choose specific countries or regions within which you'd like to file individual patent applications. And this step requires compliance with the national laws of each selected country, but it's a much more condensed and easier process to go through the PCT route. So utilizing this very structured timeline ensures that you have adequate time to, one, evaluate the patentability of your invention, two, explore potential markets that you might not have initially thought to expand into, and three, it will help you streamline the international filing process. So it's much less painful than it might be if you were to try to file individual in each country. And then another program by which expedited prosecution can be achieved is the Patent Prosecution Highway Program, or as we call it, the PPH. This is not exclusive to the US. There are many countries that do partake in this. And essentially what occurs in this program is that once you have received an allowance or an indication of allowance on at least one claim at another participating patent office, so that could be the patent office of another nation, you can then request expedited examination of those claims in any corresponding applications that have been filed in another patent office. So, for example, if you were to file in the US and Japan simultaneously, and you have an indication of allowance on a particular claim in Japan, and it seems that you would be moving forth with allowance in Japan, you can then request expedited examination of that claim in the United States, in the USPTO, to hopefully speed up the prosecution process. So it leverages fast-track examination procedures already in place among participating patent offices to allow applicants to reach final disposition of a patent application more quickly and efficiently than would normally take place. It's also really important to note that there are no fees under the PPH program, which makes it all the more appealing to applicants. Now I'm going to pass it back to George to discuss some intellectual property strategies and considerations for startups specifically.
Thank you, Amber. So some of the IP strategies considerations you should be thinking about. First of all, think about IP early and start developing your IP strategy in the early stages of your startup if you haven't already. Determine what forms of IP are best suited for protecting your company's assets, products, and services. Maybe trademarks may be suited if you're a service company, but if you're also making products, think about patents as well. And always align your IP strategy with your business objectives. Work together, management, researchers, your outside patent counsel, everything should be aligned. So your patents are issued to protect your products. Let's say there's redesigns during the development phase. You should make sure your patent attorney knows of the redesign. Perhaps another patent application should be filed, or maybe the initial patent application covers the redesign. And always look at management for any marketing business objectives that they may be thinking about. For example, maybe they're coming up with a trademark for your new product launch. Make sure that trademark is cleared and available in the countries where you want to sell it. And develop an IP budget and account for growth, defensive IP, new breakthroughs, and maintenance fees. Put on your pitch deck what some of the investor funds will be used for. Include the IP budget in that list of things. IP is important. It should be identified in your budget and also to investors. And also another thing that you should be looking at is consider licensing university-created IP. It can save you money on research costs, and it's already patented, or maybe it's patent pending, and you don't have to wait 2 to 4 years to get patents. And universities are always willing to license their IP to companies in the industry to get a royalty back. And in return, they also look out if there's infringement on their IP that they license to you. They will go back to court on your behalf to make sure that their IP is not being infringed. Always involve a patent attorney early in the R&D phase to look at perhaps doing a patent search to see if what you're working on is patentable. Are there any patents that potentially could block you from going into the market and selling your product? All these things involve a patent attorney who knows how to analyze patents and also analyze search results to be able to guide you along your R&D phase. And consider filing provisional applications early and often as your technology is developed. They say file early, file often. You can file more than one provisional application during that 1 year before you convert your first filed provisional to a regular application. Like Amber said, you don't need to file just one provisional. 3 months later, after you filed your first provisional, you have some data. Maybe you have an alternative embodiment to your original idea. You can file a second provisional application. And prioritize your patent application filings, draft claims that protect existing and future markets. Consider the fast track examination or track 1 in the US and also the patent prosecution highway to quickly get your patent portfolio built up and also in a more inexpensive way through the patent prosecution highway, which requires no fees. And identify key events that will trigger patent filing deadlines. If you're gonna be given a talk, maybe you have an article coming out, that will be considered public disclosure. Make sure you file your provisional or non-provisional application before that happens, before any release date of your product, and also before you make a sale or an offer for sale, you should be filing your provisional or non-provisional application. These events trigger a grace period in the US. So if you have not filed your patent application and you go to a conference and talk about your invention, now in the US, you will have a 1-year grace period to file your patent application. But in most countries, you won't have that benefit. In most countries, you won't be able to file. So it's important to file your provisional before discussing with somebody without a non-disclosure agreement or releasing your product or making an offer for sale. And finally, just some information about our firm. We're an intellectual property law firm. We have attorneys and patent agents with various technical and scientific backgrounds. So any technology that comes in, somebody in our office has some experience or the expertise to understand it. So we are engineers and scientists as well as being patent attorneys. And thank you for listening, and we'll take some questions. And of course, feel free to reach out to us, connect with us on LinkedIn. You can send email to myself and Amber, and we can also get you these slides as well and give you any further information or set up a meeting with you if you have specific questions about your startup that you want to discuss with us. And now we'll take questions.
Hi, George. It's Keith. Thank you very much. So twofold. If somebody's challenging me, do I need an IP attorney? Do I need a litigator? Who do I need as my counsel?
Sure. Thanks, Keith. So if somebody will be challenging, for example, you put a product in the market or a brand and you get a cease and desist letter, usually that's what you'll initially get. Sometimes they may sue you initially, but for the most part, you'll get a cease and desist letter. If it's a patent, we can review the cease and desist letter, look at the patent, look at the allegations being made. If there's some truth to the allegation, perhaps there's a broad patent that we weren't aware of or your company wasn't aware of when you brought a product to market, we'll look to see if there's a potential design around, or if we could work out a licensing agreement with the other party, the patent owner. And if it's a trademark and it's somebody that's saying that they have a similar registered trademark that you are infringing upon, maybe that's something we should also take a look at for potentially changing the brand that you may have. That's why it's good to do a trademark search. Sometimes it's not a good idea once you're out in the market to find out that you didn't do a clearance study, do a trademark search, and now you have to rebrand. So trademarks sometimes are harder to overcome because somebody will not be willing to give you a license, like in a patent situation, or there may not be an opportunity to design around. You, in a trademark sense, you may have to rebrand if somebody has a similar name or the same name as you in the same goods and services. But when you get a cease and desist, always reach out to a patent attorney, intellectual property attorney to look at and let you know what the best strategy will be.
Great, thanks. We have a question that says, if I have developed a software and the function is similar to other softwares in existence, do I need to be proactive in verifying that I am not infringing on an existing patent?
Yeah, that's a good question. So that will require what we call a freedom to operate investigation. So you may have a software product in the market, and if you think that somebody may have a patent on the idea, or even if you just want to be risk averse and find out if that's the case before you release your product, which we recommend, especially if you're doing something technical and not normal data processing or data gathering. But if you're doing something technical, like using AI, machine learning, predictive modeling, maybe looking at patterns and analyzing patterns. If the software involves something technical in nature, it's always a good idea to do a freedom to operate study. In that case, we'll take a look at unexpired patents. We're not concerned at that point with expired patents. We're looking at enforceable unexpired patents, looking to see if there's some patent out there that may cover some of your technical solutions, technical improvements that you may have done, and advise you accordingly. If there are, let's say, a couple of patents that seem troubling, we may want to look at them to see maybe they're too broad, maybe they were invalid. A patent is presumed valid when it issues, but there's ways to also challenge a patent. Maybe the examiner missed some prior art when they did the examination process. And in that case, we may be able to give you an opinion that the patent is invalid. So don't worry about it. And that opinion could be like an insurance of, that you may have in case somebody comes after you that owns that patent. Alternatively, maybe we can ask for a license if we think there's some truth to them, or you thinking or us analyzing and saying, hey, it might be prudent, get a license. Therefore, you don't have to be concerned about this particular patent if it's really close.
Great. What about how would you advise anybody on their go-to-market strategy if they're ready to sell, they've manufactured, but yet they haven't really dotted the I's and crossed their T's on their own protection?
Sure. So if you're ready to go to market, it's always good to make sure that you talk to a patent attorney or a patent agent like me or Amber to figure out, is there something patentable here before you launch? If you do launch, like I said, you have that 1-year grace period to file in the US. So if somebody's out there that already launched a product and you think you may have something patentable, but you never looked into it, there's still time in the US if you're under that 1 year. And in some other countries, like Canada, gives you sort of a grace period, but the US is the best at giving you at least a year that's codified in the rules that you can actually file a patent application after you launch. But if you haven't launched yet, always reach out and let us know, do you have something patentable? We'll do a patent search and patentability study and let you know if it's worthwhile to at least file a provisional application before you launch, and then consider during that 1 year while your provisional is pending whether we should be filing a patent application based on our search results. But at least get a provisional on file is a good idea.
And so for most startup companies, especially if they're serving the oral health market, after the United States, a lot of people go to the US first for their market because of the size and scope. But next they'll go to Canada. And, then you have the issues of French language for, Montreal and Quebec. But do they need to find, their own counsel in Canada, or then, of course, when it comes to the EU?
Sure. No, we're once shop for everything. So you come to us, we can't file in Canada, but we have relationships with Canadian law firms and European law firms. So when it comes to patent applications, a provisional application will first be filed in the US, then a non-provisional application and a PCT can be filed by our office. But then when you get to that 30-month stage where you have to file in individual countries, like Amber showed in that timeline, at that 30-month, if you tell us you want to file in Canada, Europe, Australia, China, we have law firms that we reach out to, give them your application and tell them to file it in their country by the 30-month date. In some countries like Europe, some jurisdictions, EU, they have 31 months from the initial priority date. But we'll manage all that process for you. We'll manage the international filings, the responses to the foreign law firms. They may need a power of attorney. They may need you to sign some documents. We'll work that and manage that process. And then, of course, when the international patent offices examine your application, we'll take a look at those examination reports and respond to them in due course.
And when you work with your clients on applications, obviously you can't be so overly broad, but how about the opposite? Could you be way too narrowly focused to your own detriment?
Yeah, Amber, you want to take that question?
Yeah, sure. So generally, we try to start as broadly as possible to really give the client as much cushion as possible when it comes to potential infringers that might later create patents that could potentially, touch on what the client has put forth as their invention. And so generally what happens during the prosecution process is when we receive those office actions that I mentioned from the USPTO, we will generally, in many cases, amend the claims that we initially filed. So those very broad claims to little by little narrow them down until we can get protection. And so, yes, it is definitely detrimental to go super narrow from the beginning because it could be the most minuscule thing that an infringer can do that would make it so that they're not infringing on your patent. So that's why we, or your invention rather. So that's why we like to start. The best practice is to start broad, try to claim as much as we possibly can without really getting into the nitty-gritty of your application, and then amend and narrow down as needed to advance prosecution later on.
Thank you. Wow, there's a lot to know, and I guess, and glad there's great resources like you who obviously, combined have lots of experience in this, and it's, there's all kinds of IP attorneys and, you guys clearly understand, the healthcare space. So that's really great to hear.
Sure, yeah. One of our specialties is medical devices and digital health solutions. So definitely we have a lot of expertise in that field, as well as other areas.
Great. Okay, we never ever go over an hour, so we are going to end it promptly on time. And we thank you, Amber. Thank you, George. And we will be sharing the rebroadcast link and with your contact info. Thank you very much.
Great, thank you.